as we kind of go along. Welcome everyone to Selling Your Business, the 5 things you must know. We are going to talk about for both business owners who are planning to sell their business now or in the future. And little disclaimer, we are going to be talking about some pieces of legal education, and we're going to be talking about a little bit about tax. Nothing that we are sharing today is specific legal advice. In order to have specific legal advice, you'd have to hire Spiro or I. So we would enter into an attorney-client relationship. We know about your specific situation and needs. So everything is educational. And let me know in the chat if you recognize who that is from, what that image is from. And what we are going to be talking about today is the 5 things you must know. And Axel is going to be talking about how much your business is worth, how to maximize the value of your business. Then Spiro is going to be talking about preparation and due diligence and purchase agreements and closing documents. And then I'm going to round it out with some estate planning and asset protection. And this really is for you if you are a business owner or an advisor of business owners and you're considering selling or your business now or in the future. So I'm going to turn it over to meet our presenters. First, Axel, if you want to give an intro about yourself.
Yeah. Hey, everybody. I'm Axel Fleischli. I work with Transworld Business Advisors as a licensed business broker. And a little bit about myself. I graduated from Colorado State University up in Fort Collins. And I did a semester abroad at Schema Business School in France. And I've been working with Transworld Business Advisors as a licensed business broker ever since school. So some things that I love to do are getting outside in Colorado. Definitely try to take advantage as much as I can of this amazing state. About 4 or 5 years ago, my girlfriend and I, that's the picture in the middle, we went and traveled to Southeast Asia. And then bottom left is a picture of us skiing in Silverton and then some mountain biking, of course. So that's a little bit about me.
All right. And Spiro, why don't you share a little bit about you?
It's Spiro with Hristopoulos Law. So a little bit about me. I'm actually born and raised in Colorado. I also attended Colorado State University for undergrad. And then I went to the University of Denver for law school, knowing I wanted to focus in business and real estate law. So after law school, I worked at a smaller firm in the Denver metro area, focusing on business and real estate transactions, and then eventually made the leap to founding Hristopoulos Law. And then just some fun little things about me. I enjoy kind of a lot of the Colorado stuff, so hiking, camping, and skiing. So I'm getting excited for the snow and the mountains starting.
Great. And for those that just joined a few minutes late, you are in the right space at the right time. We just kind of let you know a quick overview of what we're going to be talking about, and then our introductions, and then we're going to head into the program. So you're here at the right time. And then my name's Pam Maass. I'm an estate planning attorney. And really a quick background on me. I grew up in Arizona, worked as an engineer before I went to law school for a company called CH2M Hill. And then graduated from the University of Colorado Boulder in 2010 with my law degree. So I've been practicing law for 11 years. Started off as a deputy district attorney and then went to work for a larger estate plan firm and a litigation firm, and did a lot of litigation. So I have some stats there with jury trials and verdicts. I always like to share those because now that I'm on the transactional side, I really like to bring that litigation experience to help people plan and protect their loved ones. And then my loved ones are in that photo on the right. My daughter is 1 and my husband, and we were recently, our firm, Law Mother, was recognized as one of the top estate planning firms in Denver by 5280 magazine. All right, so I'm going to turn it over to Axel to start us off with the first 2 key things to know.
Awesome. Thank you, Pam. Also, thanks again, everyone, for joining us today. Yeah, so these are some of the topics that I'll cover. So how much is your business worth? How to maximize the value of your business, bookkeeping and financial considerations. And then that'll lead us to legal considerations, which Pam and Spiro will head. Awesome. So how much is your business worth? There really is no one way to value a company, but of course it's best to leave it to experienced professionals. So what we tell most people or most business owners is your business is worth what a buyer will pay for it. So that's the fair market value, the price the qualified buyer will pay for a business in an open market. However, the business or most small businesses are traded based off of sellers' discretionary earnings or sellers' discretionary income. And when I say most businesses, I mean most small businesses. And most small businesses are valued anywhere between $10,000 and 15 million, maybe $20 million. So that's when we're using sellers' discretionary earnings for businesses within that value range. And what seller's discretionary earnings or SDE is, it is the net income that the business produces before taxes, plus interest, depreciation, amortization, any owner compensation. So if the owner is paying themselves a salary, and benefits. Examples of this would be an owner running their car payments or car insurance or health insurance or family's health insurance, family's phone bills, any sort of benefits like that, we can add those back because the next owner may not incur those same expenses. Another add back is the non-reoccurring or one-time expense. So these are basically fluke expenses that won't ever happen again, or they're not going to happen for another 5 to 10 years. So once we determine what those add backs are, we then add it to the net income, and that's how we derive the SDE. So in order to figure out an estimated sales price, we then take a multiplier to the SDE. Typically, this is how, typically most small businesses are sold with a multiplier between 2 and 4 times. So the way we derive the multiplier is based on the business industry, how long the business has been around, so how established the business is, and the reputation of the business. Also, we look at past sales, how the revenue is trending, is the business growing? And then the qualitative factors such as the management structure. So is there a manager in place or a CEO, or how involved is the current owner in the business? And then of course, like I said, the length in business. So how established is it? And then any competitive advantages. What makes you different than your competitors? What makes your business or your services better than your competitors? So those are all things that we consider when determining the multiplier to use on the SDE. And we can go to the next slide. Thank you. So how to maximize the value of your company. What we say is build your team and start early. So if you're considering selling your business in the next 2 to 5 years, now is a great time to start building your team. And who's going to be on your team? A business broker, a transactional attorney like Spiro, a CPA or a financial planner, or an estate planning attorney like Pam. So the benefits to having a team ready to go and prepare for a business transaction, we've been through the process many times, and we know how to handle any sort of problems that arise throughout the process. So we have the high level experience. We understand the industries that your business is in. We've probably sold a business within your industry or have even sold your competitor. We have the market knowledge as well. So what are businesses in your industry currently selling at, or what are the future projections of those industries? Right now, for example, construction businesses are selling for higher multiples because, I mean, as you can imagine, construction in Colorado is booming. So we also have the market reach. Within our database, we have about 25,000 buyers who are consistently and constantly staying in touch with. So whenever a new listing comes on board, we can send it out to those buyers. We're also just staying in touch with those buyers so that they know, how the market is reacting to certain businesses and industries. We also have the local and national network. So Transworld Business Advisors is a franchise, and there's over 250 Transworld franchises worldwide. So we have that extensive reach. We also control the timeline and the process. We can help with that. Essentially what this means is we're educating business owners on when to start looking at selling their business, or when to start valuing or preparing the valuation for the business, and then ultimately when to list the business. And then from there, just the entire deal process and the timeline control for that. We also have the negotiation expertise and the confidentiality. So confidentiality is one of our largest priorities. The reason for this is we don't want anybody to know that the business is for sale. If employees or customers find out that the business is for sale, some people don't react well to change. An employee may leave the business, and ultimately that hurts the business and the potential for a sale. That could go same in hand with customers. So yeah, confidentiality is a major priority, and any interested party or buyer cannot know the name of the business until they sign a non-disclosure agreement. So to further maximize the value of your company, good record keeping and documentation. So hire a professional. You suck at accounting, embrace it. That's okay. That's why CPAs and bookkeepers are there. So most of the time in a business transaction, buyers, investors, or entrepreneurs, they want to look at the financials. So the more clean your financials are, the smoother the transition and transaction is going to go. And typically we say 3 to 5 years of business financials. So this will consist of balance sheets, P&Ls, and business tax returns. Then of course, any current P&L or current balance sheet. So just have those in line, make sure they're as clean as possible. That'll make for a very efficient and clean business sale. Other documents to pay attention to are the document standards, any business plans or processes and procedures. This also helps through the transaction and the training and transition, because a buyer can look to these documents and better understand the business when reviewing these documents. This also helps sellers better understand their business when they set these up. So another thing is just really know your numbers. It's very, very unattractive to buyers when they're asking the sellers or asking us about certain expenses or revenue changes, whatever it is in terms of financials. Sellers and business owners really need to understand them. I've seen a lot of times buyers asking the sellers questions, and the sellers don't know how to answer some of the financial questions, and immediately the buyers lose interest. They lose trust as well. So that's a huge thing, is knowing your financials, basically doing your own due diligence on your company. So that's something that your team and you as a business owner should be doing 2 to 5 years before a sale, is doing your own due diligence on your company and really understanding and knowing every inch of your business before going to market. Other things to consider are setting up customers, vendors, and suppliers. So there's a risk of customer concentration. Make sure the customer concentration is spread out. A lot of times it is unattractive for buyers looking at a business where most of their revenue, maybe 50% of their revenue or more, comes from one customer. Because if the buyer takes over and that customer disappears, there goes half of the revenue or more. So making sure that the customer concentration is spread out. And then of course, contracts too. Make sure the contracts are clean and in place. This is also very attractive to buyers to see, hey, some of the customers or vendors have contracts for the next 6 to 12 months or longer when the buyer takes over the business. So that is also very attractive. And then, to further maximizing the value of your company, management and employee considerations. So number one thing, and this is probably the most important thing to buyers, is an absentee or a semi-absentee run business So if you can start to remove yourself from operations as the business owner to become more semi-absentee or fully absentee, you have a strong management team in place or a CEO in place that the new owner can rely on, that is very, very attractive. And from there, the importance of the key employees. So establishing those roles for each employee and making sure the employee understands their roles as well. Other intangible considerations would be technology, just staying up on technology within your industry, any data. So if there's any equipment data or customer data, CRM systems, just staying up to date on all of that, really understanding that data. And then of course, the brand and culture, making sure that the brand and culture is appealing to the entire team, to the industry, and of course, to the buyer or the next owner. So that is all the free consulting I have for today. If you'd like to get together for coffee or lunch, I'm glad to do so. I'll put my contact information in the chat. And thanks again, everybody, for being here.
Hey, Axel, this is Jim Kreitman. Can I just ask you a quick question?
Yeah. Hey, Jim.
Hey, what's the difference between SDE and EBITDA?
Yeah, so SDE considers interest, depreciation, amortization, whereas EBITDA doesn't consider any of those. SDE also considers the owner's compensation and owner's salary.
I mean, SDE takes that. You mean SDE, in addition, takes that out to give a greater value than EBITDA is what you're saying, correct? Correct.
Yep. So we add all of that stuff back.
And just another crazy question. It seems like the multiple you were talking about, 2 to 4, is that because you're talking about private businesses, or is it because just from experience, sometimes you get much higher multiples? Obviously, well, there's no question you get much higher multiples on publicly traded companies, but is the 2 to 4 from a private standpoint, does that vary greatly? Is it 2 to 4 on average, or is it 2 for some things and 12 for other things? And if you're a high flying brand, it's 16 or whatever. Is it widely varied, or is it pretty generally in that 2 to 4 range?
I would say in the small business sector, so really anything under value of $15 million, what we typically see and what we average is 2 to 4 times. Now, if your EBITDA or your SDE is, usually over 3 or 4 million, that's when the higher multipliers can start to come into play.
Thank you.
Yeah, good question. Thanks, Jim.
Awesome. So I'll transition a bit and I'll be discussing the legal matters kind of relating to sellers, specifically with regards to the agreements and contracts associated with the sale of your business. So I want to reiterate a little bit on, Axel kind of touched this, but want to put an emphasis that preparation from the seller for the sale of their business is extremely important. So one of the first things to do is make sure you're preparing your records and contracts. So this includes all internal corporate documents, whether it's bylaws, if it's a corporation or operating agreement, it's the LLC, as well as supplier and customer contracts. With the contract specifically, you want to have a clearly defined and tailored agreement so it's easy for the buyers when they're coming in and doing their due diligence. They know what obligations you have, and when they come in eventually and fill your shoes, what obligations that they will have. As well as, ideally, you want all your customer contracts to be assignable, especially if it's a asset purchase. All contracts will need to be assignable. Next is clean and accurate financials. As Axel mentioned, the easier it is for buyers to read, and the more that you're able to answer questions that any buyers may have, the more trust you build with the buyers, and it just tends to be a much smoother process. Next is resolving any open items and matters relating to your business. So this can be anything from outstanding taxes owed, any litigation matters, employment matters, just minimizing or ideally kind of making sure all those matters are closed by the time you're ready to sell your business. And then lastly is to make sure you've created your advisory team. So this includes CPAs, business brokers, business advisors, an attorney that's specialized in mergers and acquisitions, as well as an estate planning attorney. Having a good team behind you will help with preparation, as well as during the process and after the process of the sale of your business. So one of the first agreements included in the sale of your business is what's called the letter of intent. It's also referred to as the LOI. And this is a non-binding agreement between the seller and buyer. Generally speaking, there's usually a few binding terms in there. So any confidentiality provisions, if you don't have a separate NDA, it'll be in the LOI, as well as an exclusivity period will typically be thrown into the LOI. And the LOI is really used as the roadmap for the purchase agreement and the closing documents. So it is, although most of the terms are not binding, it is important to make sure you have a well thought out and thought through letter of intent, because you will be referring back to it a lot for the agreements going forward. So in the LOI, some things I'll mention that are included. This isn't a full list, but just some of the key items that you'll see in there. One is just a description of what is being sold. So if it's an asset sale, what assets are being sold, tangible and intangible assets. And if it's a stock or membership sale, what shares or membership interests are being sold, whether it's, one owner or if it's you're buying 100% ownership in the business, just a clear description. Next is the purchase price. What is the purchase price? That's always the most, attractive thing for the sellers and the most important thing, as well as the earnest money deposit and when it is refundable to the buyer and when it is not refundable, as well as timeframes associated with the deal. So a target closing date, as well as a due diligence period as a couple examples. And one thing to note with timeframe, if it's a finance deal, especially if it's involving SBAs or third-party lenders, your target closing, you can usually add anywhere from a week to a month to what your target is, just because at the end of the day, you can close as soon as you get financing on the transaction. And then lastly is conditions that are required to be met prior to closing. So a couple of examples of these are the buyer's satisfaction with due diligence of your business, and then as well as the buyer receiving financing on terms that are acceptable to the buyer. So once the LOI has been signed by both the buyer and the seller, this is typically when the due diligence period starts. So the due diligence period is the period where the buyer is performing a deep and thorough inspection of basically everything relating to your business, from your contracts to your financials, to basically everything. So it's important for sellers to be transparent and honest. If you start, not telling the full story, one, it can come back to bite you, as well as you can lose trust with the buyers and eventually potentially lose out on the deal, as well as having your due diligence items in order. And that's where preparation, as we discussed, is key, especially when it comes to the due diligence documents. The quicker you can provide all the due diligence items to the buyer, the smoother it tends to go, and as well as the more informed sellers typically are of kind of their contracts and financials. So they're usually able to communicate and answer any questions that sellers or buyers may have regarding any of your due diligence items. And then during this period, both the buyer and the seller are also negotiating the purchase agreement. And so the purchase agreement is typically the most negotiated document in the entire transaction. And there's three structures for the sale of a business: stock sale, asset sale, and then a merger. We're going to ignore the merger for this conversation, just because in the small business world, the two main and most common structures are stock sale and an asset sale. Kind of how the names kind of give them away, but a stock sale is essentially where the buyer is purchasing all of or a portion of the ownership in a corporation or LLC. Where on the asset, in an asset sale, the buyer is just purchasing either substantially all of the assets of a business or certain assets of the business. And in a purchase agreement, there's it's usually a pretty thorough and longer agreement, but I'm going to focus on some key provisions that you'll find throughout the agreement. So one of them is just what is actually being purchased in the sale. So if it's an asset sale, you want to have specific and clear descriptions of what assets are being transferred to the buyer. Usually you'll have a small list of excluded assets. And this is where it's important for sellers to know what they are selling and what items they have bought with company money and through the company name. A lot of times cell phones, sometimes personal vehicles are bought through your corporation or LLC. So you'll want to make sure you have a clear understanding of what assets are actually owned by the LLC and or by the your business and what they're being sold. Second is a section that's defining the purchase price and specifically how the purchase price is being paid. So this can be anywhere from a cash deal to a lender finance deal to a seller finance deal, or a hybrid of two or all three of those options. So so you want to have a clear understanding of what or how payment is going to be made to the seller when closing happens. The next section is the representation and warranties. This section is one of the most important. It's kind of the meat and bones of the purchase agreement. And I'll hit on it more in the next slide, but as a quick little summary of what's to come, essentially the statements and kind of promises that the seller is making with regards to the business and the assets that the business owns. The next section you'll typically find is what's called the conditions of the closing, similar to what I mentioned in the LOI. It's the conditions that are necessary to be met so that the parties can close on the deal. So it's typically buyer satisfaction with due diligence, buyers receiving financing for the deal, as well as the approval of any third parties that are necessary. So this can be landlords approving the assignment or approving a new lease for the buyer, just as another example. And then the next section is the post-closing obligations. And this section, it's really most of the obligations here are on the seller. A couple of the main obligations are the non-compete agreement. So when you're selling your business, buyers will typically want to have some type of non-compete so they know once they close on the deal and take over the business, you're not going to turn around and start up a competing business. In addition to that will be what transitional assistance you'll be providing to the buyer. So once you close on the deal, there's usually a short period, anywhere from a few weeks to a couple months, where the buyer will, or the seller will stick around to assist the buyer with the transition of the business. And then the next section is an indemnification provision, which is it's really another post-closing obligation on the parties, and it relates to any breaches associated with the purchase agreement. And it's crucial for buyers, but it's also important for sellers to be aware of. So this provision provides is where the buyers will use if they find an alleged breach of representation by the seller, typically after closing. So for example, the buyers are running the business and they find out that there is some litigation that was out there that the sellers failed to disclose, or something else that the sellers failed to disclose. They will go through this indemnification provision. And for the sellers, it's important to negotiate a cap for damages relating to the indemnification provision, as well as limiting the survival period in which the buyer can bring a claim against the seller for any reps and warranties or anything relating to the business prior to closing. So as mentioned, the reps and warranties really are the meat and bones of the purchase agreement when it comes to really the buyer and the seller. So there are seller and buyer representations and warranties, but the vast majority of the representations and warranties are on the seller side. And what the representation and warranties are, they're really statements that the seller is making to the buyer about the condition of the business and its assets. And as I mentioned before, it's really the basis for any indemnification or claims post-closing that the buyer may have against the seller. So some examples of representations and warranties are that all taxes have been timely filed, or if you're closing in the middle of a tax year, that they will be timely filed, that the business is not in any current legal proceedings, and as well as that you've provided the buyer with accurate financials regarding the business. And then there's usually a list of about, depending on the deal, anywhere from 10 to 30 representations and warranties that you're making specifically about your business. And it's important for the sellers to understand each one of these representations and warranty. And if there's one that they cannot say honestly, put their name behind, then it's necessary to disclose what that issue might be. So if there is a employment issue that's still out there, to making sure that you're disclosing that to the buyers, and then creating a carve out if that's necessary. Next slide, please. So once the purchase agreement has been finalized and signed, and any third party consents, and as well as financing has been approved, you finally get to closing table, which you've been working for a few months now, typically. And at closing is when you'll sign numerous documents, often referred to as the closing documents. So I'll touch upon the most common closing documents. So typically, if it's an asset sale, there'll be a bill of sale, which transfers title or ownership in the tangible assets to the buyer. And then the next document you will typically see is an assignment and assumption agreement. And the assignment and assumption agreement, anything from a lease assignment, that's assigning over your lease to the buyer, to an assignment of customer contracts or vendor contracts. And this is important to, if possible, make sure that all of your leases are in order, as well as contracts, and that they have an assignment provision. Typically with leases, you will need to get the landlord's consent to assign them. But with your customer contracts, it's something that you can kind of prep for prior to the sale to make sure that they're easily assignable. The next closing document is a non-compete agreement, and in the non-compete agreement, it'll explain, the duration and the radius of where the seller is not allowed to compete with the business, and what defines competing or soliciting with the business. The next agreement is what is referred to a lot of times as the corporate minutes. It's really an internal document for your LLC or corporation where you're acting as shareholder or a member or manager of an LLC, and properly holding the meetings required to sell all of your assets or substantially all the assets of the business. And then the next document is a promissory note. And this, you'll see a promissory note if there's seller financing, and it'll outline the terms of, one way to look at it is the loan document. If the seller is financing it, it'll outline the amount that is owed, when payments are due, interest, etc., how it's to be paid. And then lastly, you will have loan documents if this is a finance deal through a bank. And the loan documents are mostly on the buyer side, but there are some stuff that a seller may be required to sign, and the sellers will be required to disclose some financials as well as other information during the financing period. And then once all of your closing documents are signed, and then the seller has received the purchase price, and they are officially closed on that transaction.
All right. Well, thank you, Spiro. So I'm going to kind of round it out with number 5, which is kind of the estate planning and asset protection side of selling a business. And then at the end, we're also going to take all of us Q&A. We'll stick around. So if you have more questions, feel free to wait till the end. And what are kind of the estate planning and asset protection priorities for business owners to think about when they're preparing to sell? Well, there's kind of 3 priorities, I would say. that we're going to focus on. And the first is, what happens in the case of death or disability. The second is asset protection and wealth preservation. And the third is tax minimization. So what happens to your business or your funds from a sale if you die or become disabled? And really, if you don't have any type of legal plan in place, any type of estate planning document in place, then your no plan is going to be the default government plan, which is expensive, as you can see from this image. And the government plan is called probate, which is a court process. It's often called a lawsuit against yourself for the benefit of your creditors. So if you were to become incapacitated or disabled as a business owner, and you don't have specific documentation in place about what happens, then your loved ones, your business partners are going to have to go through probate process to figure that out. And that court process is going to be lengthy, it's going to be public, and it's going to cost money. So we'll talk about how to avoid that. The number one misconception is that a last will and testament will take care of it, but it won't. Wills are not enough. They contain instructions to a judge, so they go through a court process. So what is a living trust? Well, a living trust is an option that a lot of business owners use when they're planning to sell a business and before. And you can consider it a substitute for a will. It allows you to protect your assets, to transfer them, but it avoids the probate process if you are ever to die or become incapacitated. So who should consider a living trust? Property owners, if you have an estate over $75,000, if you have minor children. As a business owner, you should consider it, and if you have any special need beneficiaries. And a properly drafted and properly funded trust will avoid the probate process. So holding your assets, your business and personal assets in a living trust, some of the advantages are you can save those probate costs, which on average is 5 to 9% of the estate. The time which court process takes, which is 9 months to 2 years. You can keep things private instead of public. You can have your choices honored, and you can also have disability protection. The other benefits are the asset protection and wealth preservation benefits, which is what we're going to talk about next. So what are we worried about when we're talking about asset protection? And Spiro and Axel kind of talked about this, and Spiro a little bit more, this idea of if there are pending lawsuits or any kind of pending types of litigation, how that might impact your sale. A lot of times when we're talking about asset protection, we're worried about kind of two types of cases. One is inside liability, so risks related to the business specifically. So if you own a medical practice, you might be concerned about medical negligence. If you own commercial space as part of your business, you might be concerned about someone slipping and falling on the property. Outside liability is risks unrelated. So you're in a car crash, someone sues you, or you get in some type of business dispute. Can they pierce into your personal assets? Can they force the sale of your business? So when to do asset protection for your business? Well, the answer is now. If you wait too long and you do it after a claim or a harm has arisen, it's a bad thing. It's called fraudulent transfer. So if you fraudulently transfer your assets, meaning you already have a harm that occurs, so you know that an employee was harmed or a customer or someone was harmed, not a lawsuit filed. So you don't have, it's not when the lawsuit's filed, it's when you know the harm has occurred. And then you go and start transferring your assets. Well, there's separate claims that can be brought against you under the Colorado Fraudulent Transfer Act. And there's also a federal Fraudulent Transfer Act, which increases penalties against you in any type of civil litigation. You also can, if claims are brought against you, you can result in frozen bank accounts. So the example case I had to describe is I had a case where I tongue-tied there for a minute, end of the day. I represented a sex assault survivor. So she was a patient at a medical practice, and her medical provider, her doctor, sexually assaulted her. And she made a claim to the medical board, and then she hired us. When that medical board claim came in, the doctor who owned the real estate where his property was decided to transfer the real estate to his property. to his wife. He transferred all his real estate to his wife, and he transferred all of his business assets as well. And so I was able to find that out before I filed the lawsuit. And then under the Fraudulent Transfer Act, I was able to freeze all of his assets before we even filed our lawsuit. And that's because I was able to go to a judge and say, there's a risk he's going to continue to transfer all of his assets. And so we asked that they be frozen. And so when I served my lawsuit, his everything was frozen. So he didn't have access to anything. So it really put us in a different posture, but that's one example of why it's a bad thing to do that. So don't do that. And I don't know who recommended it to him, but it's a bad thing. So how much protection do you need from an asset perspective as a business owner? Well, I always kind of start with some different layers. So your first layer of defense is always insurance and estate planning. And then the second and third layers are going to be different types of business entities. So if you own real estate or you own separate types of businesses, you want to put them in separate entities so that if there's a claim against one, they're not going to be brought against all of them. And as Spiro was talking about, you don't want to kind of have that intermingling for a lot of reasons, but also if you're planning to sell a business, it's going to impact, as Axel talked about, the valuation. And then the more advanced strategies are, do you want to get a holding company involved? And do you want to have a holding company in a state like Wyoming? Wyoming tends to be a good state for as a holding company because they have charging order protection. And what that means is if there was a judgment against you, so someone sues you and they win and they have a judgment against you, and can they force the sale of your business or not? And here in Colorado, they can, but in Wyoming, they can't. So they can only attach against the distributions you give yourself. So that's why a lot of people end up using Wyoming holding companies, or another state that's popular is Delaware. There's lots of others. And then kind of the fifth strategy is using more advanced asset protection trusts as well to shield some of the assets. So really what I encourage my clients to do is analyze their exposure. What are the protected assets that they have? Looking through right now, if something were to happen, what is protected and what are their unprotected assets? And that really will gauge the level of types of planning you want to do. The other piece when it comes to protecting assets is protecting assets for your family and your beneficiaries when you pass away. So that's the other piece to talk about. And if you don't have an estate plan in place, the default plan is for distributions to go outright to your children when they reach 18. And so that can be a concern if your children or your heirs, if you don't have children, the other people in your life aren't responsible if they're just going to blow all the money. Or if you have concern that they're going to have future divorces or future creditors that could come after this money. So with a plan, you can put in place a lifetime asset protection trust for your beneficiaries and really build in the guidance for them to effectively manage the money, but also protect their inheritance from future creditors and future divorces. And then the third priority is really talking about tax minimization. And without an estate plan in place, who comes first? The IRS. They get their cut first if you don't have a plan in place. And then with putting some asset protection and estate plan in place, you can minimize those taxes ahead of time. And really, it's a team effort working with your financial advisor, your CPA or tax lawyer, and your estate planning lawyer to make sure both your estate tax and your other types of taxes for your business are minimized. So we're going to talk about at the end how you can get in contact with all of us, but I have a kind of a special offer for folks who are interested in getting an estate plan or asset protection plan in place. Really, the biggest risk to you, your family, your business is procrastination. Estate planning and asset protection planning is one of those things that people tend to put off until it's too late. So I really want to make it easy for you to get a plan in place. So I have a $1,000 golden ticket offer for you today for those that attended. And then we have quite a few people who have signed up to watch the recording. So if you're watching this recording later, I'll also offer that to you. And what that gift is it's two gifts. The golden ticket is a complimentary family wealth planning session, which is normally $750. And if you have an existing estate plan, I'll do a full 50-point audit. If you have no existing estate plan, I'll go through with you with all of your assets and talk to you about all the specific strategies that based on your specific needs and based on Colorado law and how everything's currently titled. So I normally charge $750 for that session because it's 2 hours of my time. And I also prep for the session ahead of time and review all of your documents. But because you came today and are getting educated, I will waive that fee. So there'll be no charge. There is one catch, right? Because there's always a catch. In order for me to give you the most value, you will have to submit some pre-meeting homework ahead of time. And that's really to your benefit, because if you submit it, we make it super easy for you to do it online. And if you submit that, I'm able to do calculations ahead of time, especially on tax type issues. And I'm able to get into the meeting and give you specific legal advice and give you the most value. There's no pressure to work with me at the end of the session, but if you do, I take $250 off your estate planning services. So if you would like the golden ticket offer, send me a DM in the chat, or you can go to lawmother.com/go and you can redeem that. You can also book a 15-minute call with our office there if you have more questions, or if you'd like to book a family wealth planning session, you can do so at that link. And that's what pulls up with the link. You can set up the 15-minute call, or you can set up the family wealth planning session. And then we do secure, if you do it online, we do secure it with a credit card, much like when you do a doctor's appointment or a massage. We don't charge you unless you are no call, no show. It's really because I only have so many of these slots a month and you're reserving 2 hours of my time. So we ask for that commitment. And then your booking link will pop up and you can get it scheduled. So we are all three here to answer some questions. I know Axel put his contact information in the chat, and Spiro, I don't know if you have, but if you can do that as well. And then we'll also send out an email to everyone who attended with all of our contact information so that you have that. So anybody have any questions? I'll kind of look at the chat box and see.
Yeah. Hey, Pam, good to see y'all. Thanks for the presentation. I have the same exact question that Cameron put in the chat. So thank you for typing that out, Cameron.
All right. So the question is, the advanced protection you mentioned in Wyoming, LLC, in Delaware or Nevada asset, is this more dependent on the amount of wealth or the risks of being litigated? Yeah, so that's a great question, Cameron. It kind of depends on a few different factors. One, it's the level of wealth that's trying to be protected. So sometimes we're putting those structures in place because there's an estate tax issue that people are worried about. And then sometimes it's based on like some of our medical clients who are in the medical field are concerned or people in the construction industry too are concerned about more litigation. So they want to put some of their personal assets away. But other times we do it structured with business owners, with holding companies in other places. Sometimes it depends on the business structure. So sometimes, I was just working with a tech company and we were restructuring everything, and they are opening up, multiple LLCs around the country. And we wanted to separate out not only those entities, but the payroll for those entities. And we wanted to put it all under one holding company. And then it's owned by a family limited partnership. And then it's owned by a dynasty trust. So that's a long answer, but that structure kind of hits like several different boxes. It's asset protection, it's a tax strategy, and then it's an estate strategy. So I would say most of my clients, when they're thinking of selling a business, most of the time they are people who are reinvesting that money, or they own other businesses, or they're going to take a large payout. So we're trying to do some type of structure to minimize their tax exposure, but also to protect all their other businesses. So I don't know if that answered your question. It was a little bit of, it depends, which is our typical lawyer answer, but it does depend. All right, great. Any other questions?
I'll just take a second, Pam, to clarify the difference between SDE and EBITDA. I saw that there was another question in the chat. So essentially they are the same thing, except seller's discretionary earnings, it does consider other discretionary expenses. So if the business owner is running their personal car payments or car insurance or health insurance, their family's health insurance plans, or I've even seen a business owner run their kitchen and bath remodel through the business. So things like that, or the one-time expenses that aren't going to happen again, SDE considers all of that as well, whereas EBITDA does not. So it ultimately helps for a higher valuation.
Quick question for Spiro on the due diligence process. Are you also looking at some of those details in those documents that the seller's providing?
Yes, I will be kind of reviewing all the due diligence documents as they're coming in front, and just making sure the big thing on the seller side is minimizing any liabilities that the seller may have after closing relating to any of those due diligence items.
And that would be both on a buyer and seller side, I assume.
Yeah, on the buyer side, it's a much more in-depth review, because you are not as well versed, and you're now just seeing those documents. When you're on the seller side, you tend to see them a little bit sooner, and the sellers have more knowledge of them.
Okay, cool. Thank you.
Question, I guess, for both Axel and Spiro. Both of you kind of talked about the value of getting a broker and attorney involved early. What have you kind of seen when people don't get, counsel involved until like the last minute, or brokers involved into the last minute? I'm guessing you're on the other side of those deals, right? And maybe it's resulting in, a lower valuation or not as favorable terms. But I'm curious kind of what you've seen as far as that.
Yeah, I can speak on, I guess, a little bit on both sides. So deals where there's not a broker involved, brokers are great for a lot of different reasons, from preparation to just kind of managing the relationships between the buyers and sellers throughout. And with brokers involved, especially a good broker such as Axel, it helps keep the deal moving forward, as well as helping with communication through the parties. The attorneys can do only so much because it's communication, especially if there's an attorney on the other side and needs to be with the attorneys, just due to our ethics rules. So that's one of the big things that brokers help with. That's not an obvious one that you would think about. And then on the legal side, if they come in a little late, sometimes they've already agreed to some terms in the LOI. And even though the LOI is not binding, it can be difficult to then essentially change up the structure or change up something that, the two parties essentially have agreed to, even though it's not binding. So you tends to kind of having to go over additional hurdles to get to the finish line than we could have avoided to begin with. And it usually leads to additional fees, caused and extend closing out further. And the longer the deal's out there, the more likelihood it is to not close.
Yeah, Spiro pretty much summed it up. I'd say, organization really, really helps. And without the organization or being prepared with the team, everything is just going to take that much longer.
All right, thanks. Well, any final questions from anyone? Otherwise, we will go ahead and close out for tonight. Thanks for everyone for attending. Thanks to our speakers. And we will have this recording sent out, and also all of our contact information here. So feel free to reach out to us if you have any other questions. And thanks for attending.
Thanks, everybody.
Thank you.
Thanks all.